Howdy, and welcome to the show. Cooper's Code focuses on legal issues and notable practitioners, distilling wisdom so we all achieve the best results for our clients. I'm Miles Cooper, and I'm very excited to share today's conversation with Rich Schoenberger. Rich is a named partner at Walkup, Melodia, Kelly, and Schoenberger, where he practiced for 37 years. This follows a stint as an Alameda County Deputy District Attorney. Rich's talent and hard work have resulted in countless record-setting trial verdicts and have led to his being invited to join the most prestigious trial lawyer organizations around, including the International Academy of Trial Lawyers, the American College of Trial Lawyers, the International Society of Barristers, and the American Board of Trial Advocates. His professionalism, civility, and integrity led to his receiving the prestigious Don E. Bailey Award in 2022. He gives back to the legal community as a sought-after trial advocacy teacher. He's managed to do all of this while taking active steps to prioritize family involvement, including coaching more than 30 of his 3 kids' sports teams while they grew up. This is not an easy task for a trial lawyer, and we explore that. We also explore his community involvement since 2013 with Bridge the Gap, a Marin City program designed to prepare at-risk youth for high school and college. I hope you enjoy this conversation with Rich Schoenberger as much as I did. If you're enjoying what we're doing here with Cooper's Code, please help us extend our reach by giving us a 5-star review on Apple Podcasts and consider sharing an episode with a friend. Welcome to the show, Rich.
Thank you. Happy to be here.
Well, I'm glad that you could be here on Pi Day, if anyone's wondering about why we've got dessert on the table.
3.14, that's as far as I go.
Well, and we're a little bit early for 159, which would be the I think the next few digits. So it's only 137 right now.
Okay, well, we'll stop the clock in 22 minutes.
We talked a little bit about this before we started, but I had not really been a Pi Day aficionado until we started going to the Exploratorium with our kids and learned that it was the Exploratorium that really kind of put that on the map.
That is news to me also. That place has moved. When I went there with my kids, who are older than your kids, we had a blast. There were always things to do and explore, pun intended. And I particularly loved that I could sit in one end and they could be at the other end, and we could talk to each other, and I'd be removed from them, which was always part of the goal. I remember I was a coffee boy at our house when the kids were little, and Monica is a coffee addict and needed her triple non-fat venti, which I know for those coffee snobs indicates that it's Starbucks, and yes, that's exactly where I would go. And it wasn't until the kids were gone and I sort of stopped being coffee boy that she was like, "What happened to coffee boy?" And I said, "I just needed a break from the kids." So I would go get you coffee. And so now it's more meaningful when I go get her coffee.
Oh, that's neat.
Yeah. And I've started to drink coffee,
which
I had never done.
Oh,
never. In the last couple of years, now I'll go maybe 3 times a week. And it is this sort of virginal vessel, a drug. It is. And so in honor of this podcast, I had a tall cappuccino.
Oh, nice.
And I feel it, the electricity coursing through my veins right now.
So were you not a caffeine person at all? No
Ever.
Tea, no. Really?
Well, tea, if I'd go to a Chinese restaurant or whatever. But no, it sort of had the natural thing going. And was a bit of a coffee reverse snob. Thought it was cool that I'd never had it. Then as I got older and I realized its virtues, especially like if I was going to go out late at night or something and have something at 2:00 in the afternoon, it would be like, you don't need to do any other drugs. You got it down. So
that we're going to cover a few different topics today,
Sure.
But that is a nice way to kind of lead into talking about your work as a trial lawyer.
Yep.
And the reason I say that is because I think of trial work as sometimes requiring long hours, even when one has reached the point where one might be fatigued.
Yep.
And coffee was not part of your your repertoire.
No, although I will say the first time I started to drink coffee was when I was in trial, for sure, because it's a 24/7 business when you are in trial. And that means ideas that come to you in the middle of the night, and that means writing them down, and that means sleeping not quite as well, but wanting to be alive during the day. I never felt like the adrenaline of trial left me during the day, but I felt like my clarity and crispness sometimes became aided by a cup of coffee. And so in the last 10 to 15 years, I would say I drink, that is the exception to the rule, is that I drink coffee most days when I'm in trial. And that's kind of what started it. And now I find excuses to have it a couple days a week. But no, you're right. It is a tiring enterprise. But those things that, have such great reward often are. It's been my experience.
So I want to take it back a little bit in terms of your career. You started, as I understand it, as a deputy district attorney with Alameda County?
Yes. And that was a job that I wanted because, and I may have told you this, but it does identify me, that my dad was dying when I was a second year in law school, was not a very good student. I'd barely gotten into Hastings, UC Law, SF. And I knew that I wanted to be a trial lawyer. And so when he was dying, and he lived for 37 days from diagnosis to death, he and I had a great opportunity to talk about me, because he loved me and he wanted the best for me, and I loved me and wanted the best for me. And so the question arose, what are you going to do? And so I asked all around of the very few legal people I knew, but I went as far around as I could in that limited area because we didn't have any lawyers in the family or anything. And it sort of kept triangulating to Alameda County District Attorney's Office, of which I knew nothing, but then I quickly learned. And this was in my second year. Come to find out, they had hired everybody for their sort of very highly regarded second year program. It was too late for me to do that. But Carol Corrigan, now a Supreme Court Justice, was teaching trial advocacy at UC Law. And I didn't have her, but I learned of her. And then I was a thorn in her side for weeks. I would sort of camp out by her classroom and say, I want a job. And she would just sort of go, what are you talking about? Kind of thing, until finally she realized that I was serious. And she called me and said, you can come in for an interview. Have I ever told you about this interview?
No.
This was wild. I remember I read, I think it's Irving Stone, but he wrote a book about Earl Warren.
Okay.
And I read it preparatory to my interview. I really wanted this job. By now my dad had died, and like I said, I was not a great student, but I knew I could handle myself on my feet, kind of thing. And Carol Corrigan, if you've not met her, is over 6 feet tall, and you add her hair and she's 6'6", it seems like. She's a powerful presence, wicked smart and no nonsense, and intimidating as such. And I went in and she sat me down and put me through a hypothetical, like within a minute of my arrival, and said, you're about to do a preliminary hearing. I barely knew what that was, and I hadn't taken evidence yet. I remember that. And she said, and the case involves a drug dealer who is not only dealing drugs, but both trafficking teenagers and dealing to teenagers, and is a really bad guy. And the officer found an ounce of cocaine in the bad guy's glove box. And so you're about to put on the preliminary hearing, and the officer comes into you and goes, hey, wink, wink, by the way, I didn't ask for permission to open the glove box. I opened the glove box, and that's where that was. I just wanted you to know that. So, you want to work around it or whatever. And she said, what do you do? And I said, And this was sort of borrowed from having read that Earl Warren book about his integrity, and hopefully having been steeped in it myself from my dad and my mom. But that was a big thing with growing up and with my dad. And I said, you dismiss the case. And I remember saying something as trite as corruption breeds corruption. And she was on my ass for 5 minutes. Oh, you're just going to let this guy walk. He's just going to go do it again, molest more kids, deal more drugs. You're okay with that? I mean, like, looking me in the eyes and just on me. And I stuck to my guns. And she said, not everybody does. And we don't want them working here.
Interesting.
It was a really kind of a cool thing. I think about 3 minutes in, I knew, because she was going so out of her way. But that was the test. And that made me feel really good about working there. And it feels Pollyannish because not all prosecutors are perfect, but at least they had that bar. And I was not alone in the people they did that to. I also remember after clerking there for a little while and feeling like I had done okay, getting the call that I got the job, and then taking the bar, and then Jack Meehan, who was sort of avuncular and everybody's favorite sort of DA. You had Lowell Jensen, who preceded him. You had Earl Warren, who preceded him. You had Ed Meese, who was like the assistant. You had these characters and these luminaries. And Jack Meehan called me up and said, and I remember where I got the call, where I was standing, and what he said after I passed the bar. He said, your dad would have been very proud, because he knew, how painful that had been for me, because I hadn't ever really experienced grief before or since. I've been really, really lucky. But it was right during that period of time when I got that job, and I loved that job. I really did. And I was determined to be as fearless as I could, that I would try anything, so long as I believed it was actionable, that the charges were legit. And they always were, but I lost 4 cases out of 18 or 19. That is a horrible record for a DA, but I learned so much from just taking it on, cases that people didn't want to take on. I was like, oh, hell, I'll take it. I remember some really hilarious moments and some intense moments, and it was a great job. Great job.
There are a couple different directions I want to go from that. And I think the first, which may be a shorter direction to go, is some of the relentlessness with which you pursued that job. And I bring that up because I know some of the lawyers or law students who listen to the podcast are thinking about, their next step. I know that UC Law recently had a plaintiff event, which was really neat to see, because when I was growing up, that was not that you found your plaintiff job by knowing somebody.
Right.
And I know that there's a relentlessness that sometimes is required. Can you speak a little bit to what drove you and why you took that approach, as opposed to just saying, well, I guess the summer program is filled up?
Yeah, it's so funny that you say that, because it has been a mantra of mine ever since, that my kids have borrowed from, and 2 of them have benefited tremendously from, by being a gentle thorn in people's sides, as I was with Carol Corrigan. And by the way I got into Hastings, I was 121st on the wait list out of 125. And I was at USF, and it cost $6,000 a year, and Hastings was $1,300 a year, maybe. And I got into Hastings because they were short on the 500th student that they needed. They had 487, they needed 500. And May Yoshida, who was the assistant to the dean of admissions, and whom I had spoken to probably 5 times and gone out over to Hastings to speak with her to see if I'd moved on the wait list. I hadn't moved a person. And when the time came for them to find the 13 students who would go to Hastings, boom. She went right down to 121 because she knew I would go there.
Wow.
So that's how I got that job. And so I would say to the listener, knowing that I am the protagonist here, I assume there will be 1 to 2 listeners. And with that listener, I would urge you, do not give up on what you want. And more importantly, without being creepy, let people know that you want it. I believe that relentlessness will take you a long way. Know it's what you want. I also think, having been on the other end, that it's nice to be wanted. And so when you show up and you tell people you want it and you show people you want it, there's a real good chance you'll get it, as opposed to sort of giving up. And it's not that hard. I find those things difficult to do, but if you want it badly enough, I overcame that reticence. So I would encourage people, young lawyers in particular, law students, to know what they want when they do, and you don't have to right away, and then go get it and stick with it. And I'm telling you, it's worked. And my kids have bought into it, and they've seen it work. And I know I've seen it work with younger lawyers to whom I've given the same advice.
Does that same approach show up in your work? And that's a lead-in, and I would object to my own question as being compound leading and not leading to discoverable evidence. However,
let me just interject to say, because it's about me, overruled. Bring it on. Be as compound as you'd like. No, go ahead.
So one of the things I think that's important to bring forward, and for anyone who has not had an opportunity to click on your profile, I recommend that they do that, because while we did a read-in in terms of who you are, your trial victories, your ability to extract resolutions from defendants without having to put your client through trial, speak for itself. And I'm wondering to what extent you feel the way in which you approached, say, getting into UC Law or getting into the DA's office also shows up in how you approach your casework.
First of all, it's nice of you to say. Secondly, I've not thought about it that way. And there's a part of me that my visceral reaction is no, that it's a different part of me that is born in competition to a certain extent, preparation for sure, comfort of being in trial, leading to trial results, leading to my ability to be believed when I indicate what a bottom line is. So you suffer from the same malady that I do, which is your desire to be a trial lawyer. Even though we have drastically different personalities, our Venn diagrams overlap almost entirely with respect to it being a need in some way, as opposed to I'll do that. That it identifies you, part of you, and it does me. And so the ability to try those cases and lose them and win some and know that I know the evidence code better than anybody allowed me, I don't mean it that the way it sounded, but
I like the way it sounded.
Yeah, that I have a comfort level with the evidence code, born in having, done a bunch of preliminary hearings and trials in just 3 short years, put me in this weird position that when I got to Walkup, I was like, what can I try? Give it to me. And I got to try this case called Quackenbush, this 911 case in the early 90s. I was in my early 30s. I had no business trying that case. It was George Shelby's case. And I just knew that he'd be okay if I took it on and over. And I did. And I tried that case against Frank Kelly and Bob Luft. And Frank Kelly was, I still think, one of the finest trial lawyers I've ever tried a case against. He's a really, really good trial lawyer. And I learned a ton from him, both in the discovery and in trying that case. But I think it wasn't that I won't give up or something, because I have a lazy streak too. And so I think it's just been this sense of feeling comfortable at it, feeling very competitive, feeling passionate about representing my client, sort of combined to push me forward in those cases. And I will say, the number of times that I almost threw up in the mornings, and gagged eating a banana because I just was so freaking nervous, are hands and fingers worth. It wasn't easy. I had to overcome that feeling, but I knew, like from that first day in trial, that feeling of being in trial outstripped that nervousness that I had in the morning every single time. And then the high that I felt after trial, just even like when the judge would say, "See you tomorrow, counsel," and I'm putting my stuff away and walking out of there. It's like, this is the thing you're good at. You tried to hook up a VCR to itself once. You're bad at a lot of things, but this thing is you're okay at. And so I just think that was what helped me. And by the way, I am not a natural, for sure. I've seen other people who are naturals in the courtroom. I am much more a product of just, mistake after mistake. I mean, there are some things I do, I have a good memory, so I immediately remember jurors' names, and I use that to my advantage without it being gimmicky. You and I have discussed that. But, there are things that come to people much more easily than they come to me, but it's okay because I am me and they are them. And, I think the thing I learned the most about trying cases is steal from people, borrow from people, but do not be anyone other than who you are, because jurors smell that. That's a long answer.
It's a great answer. I don't think it's gimmicky. I do want to comment on your juror selection method, just because I don't know of anyone else who is able to do that. And to be clear, what we're talking about is by the time you get up to go through the first 18, you have their names memorized in order and can call on them that way without having to look down to your chart.
Yeah. So first of all, I learned that from a deputy DA in Alameda County. So for sure other people do that. I remember Don Carlson, who's a terrific trial lawyer, told me that Roger Dreyer did that. He'd never seen that. So Roger Dreyer does that. And let me tell you, it ain't hard, especially if, in this day and age where you're doing questionnaires and you're actually finding out who your first 24 are the night before, or your first 60 the night before. That makes it almost cheating. And so when you have questionnaires, that's a real leg up. But even when you don't, you'd be shocked at how simple it is. And the question becomes, how important is it? And in the grand scheme of things, I used to think it was more important than I think it is. But by the same token, I know it doesn't hurt. And the way it doesn't hurt is in two fashions to me. One is you do gain rapport because people are like, well, he cares enough to know my name. But more importantly, you have an ability to flow in your general questions by being able to say, Mr. Gergich, you actually work at a butcher shop where this is served. How do you feel about what Mr. Smith just said? And so then there's this sense of freeing them not to be too shy about it. You've used their name. You've pronounced their name correctly. And if you have trouble with that, you make sure you get it until you do. I had to, write my name on my desk in first grade. I was the only person in the class because everybody else knew their last name. Schoenberger was really hard for me to spell and say. And because of that, I care about my name. And so that causes me to care about other people's names and to honor other people's names. But I think during those 45 minutes or so while the judge is doing her voir dire is when I go from being an order to I go 1, 18, 2, 17, 3, 16, and then I just jumble it up. Because if you're going to use it, it's going to be not in order. It's going to be people raising their hands to the various worry basket items that you're talking about. So you need to be able to do that. And when you say, not looking down at my notes, don't have any notes. I mean, for me, a hugely important part of jury selection is to be standing there without notes for me so that someone else is taking the notes, but that I am having a conversation that I am hopeful is about 10% me, 90% them, So it's a comfort thing for me to be able to have this discussion, to be able to know their names.
I want to go into the having somebody take notes piece and kind of to flesh out the area that I'm interested in. I'm guessing when you were a deputy DA, you did not have somebody taking notes while you're doing jury selection.
Totally true. I remember the very first trial, there was an experienced DA helping me, and I was asking questions, and he would then go to the next one. And so he sort of guided me through that. I also remember feeling really good about how I'd done, and then talking to the person who admitted that they were divorced. And for some reason that was relevant, maybe not. It was my first trial, but being completely wrong. I had the wrong guy, that it was somebody else who had been divorced, and having to, step on that and make fun of myself for that. And, but I used to do stupid things. Like if it was an arborist, I would say, I'm going to leave that alone, or I feel like I'm going up the wrong branch, And so for me, humor has either got to be self-deprecating or dad jokes. Those are sort of the only ways I'll do them. But I don't think I had anybody taking notes. And yet, sometimes you had to do what are called Williams challenges, Batson challenges. We know People versus Williams, I remember. And you had to justify your peremptories. And so I'm sure I was taking notes. I remember actually being so nervous at once when a public defender made such a challenge, and there was a big pitcher of water, and boom, knocked the whole thing over. Yeah. It sort of represented the feeling of needing to pee on myself, I think.
We were talking a little bit about note-taking and jury selection and having people present to take notes. It's a lead-in for me to how trial work has changed, or how you've seen it change over the years. And I think that's going to be different when you're working at Walkup than, say, as a deputy district attorney. But just say in the last 20 years, have you noticed changes in terms of how you staff trials, how you approach trials? Launching pad really for however you want to go with that.
Oh, it's such an interesting question that I haven't spent much time thinking about, so I'm going to sort of extemporaneously free associate here. I think that the biggest changes, I would say for me personally, are in jury selection, where I now use a jury consultant and never did until about 10 years ago, because with the understanding that the gut is the repository of all truth, I just relied on my gut. And so I was really hesitant to use a trial consultant. And now I really like having one. It's an embarrassment of riches in some ways to have someone, but especially someone I trust. I've used Harry Plotkin mostly over the years, and I do trust him, and he and I think alike. And so that's a big change. I also think the pendulum swinging up and then back down in some ways with respect to globally demonstrative evidence, but then the obsessive use with PowerPoint that I think is giving way a little bit to the infusion of, at least for me, low tech, so as to complement PowerPoint and to have things that are tactile, and, for instance, in a closing argument, to be surrounded by boards and have PowerPoint and have the verdict form, not on PowerPoint, but there, and using pens and stuff like that. And I have a favorite low-tech thermometer argument that I use that is a butcher pad and a Sharpie
Is that all visual, or can you articulate it?
I think I can use word pictures. It started about 20 years ago when I was trying a case up in Stockton. It was a good case because there was a claim of huge comparative negligence on my client's part, but pretty good negligence against the defendant. My client had been asked, he was an HVAC repairman, and he had been asked to change a flagpole at an enormous apartment complex. Not his job, but he did it, and he rested his very long ladder against a very narrow flagpole. And he got all the way up and was removing the flag, and the flagpole broke.
Oh.
And he fell some 20 feet and suffered a horrible back injury, but it was almost like a Darwin Award kind of move. And, we elicited testimony, adduced testimony that somebody a couple years before had tried to do the same thing and sort of heard a creak, and that this was the only wooden pole in the place. There were other metal ones that were equally tall and hard plastic ones, but this one was poorly maintained at the bottom, and so the wood was sort of rotting at the bottom. And we established through testimony that the negligence going back in time, and we're always, in a quest as plaintiffs' lawyers to move the negligence back in time as far back as we can to a single point of failure that precedes the date of the incident by months, years, or decades, if we can, as you know. And I was thinking to myself, well, it's a comparative case, but how do I demonstrate, other than with a timeline, that there was so much more negligence before this date? And I literally was driving by a school, and there was one of those fundraising thermometers with sort of the bulb at the bottom, and then it straightens out and then tracks upward. And you always see that it's at 60,000 or 6,000, or, they're trying to get to the top. And I thought, why not, instead of having that be a fundraiser for money, have it be a repository of fault or negligence, depending on the case. And what I did was I put the date of the incident at the very top of the thermometer. Like if it were 100% at 90, and even numerically measured it at 90, and then put a dash next to the 90 and put the date of the incident. And then in closing argument, I've offensively proved why we win. Then when we get to that part of the verdict form that talks about comparative negligence, what I did was with a Sharpie, as I'm reminding the jury of all of the defendant's negligence, and I'm doing it chronologically and sometimes interrupting with exhibits, and I filled the thermometer all the way up to 90, all with the defendant's conduct, leaving only 10%. And I said, if, as they say, it's 50-50 or whatever, I don't disagree with you. But there's only 10% left. So what we have is 50% of 10%. It's a little numerical, but there's just a smidge. So when you fill this out, it's 95-5. That's the only thing that makes sense. And it worked. And it has worked continually ever since. And it is, for me, so valuable because it is low tech and tactile. And people are watching you fill it up in a way that you can't do in PowerPoint. So I love to do that. And I found it to be an effective tool.
Do you think it would have the same impact if somebody did slides that slowly built upon themselves that had been pre-done, or is some of the power that comes with it the creation of it in the courtroom as you're doing it?
For me, being someone who writes illegibly and is a little shaky, I think it's more powerful for me to be imperfect. I am a huge believer that perfect is the enemy of the good, and that being human in the courtroom is a very valuable quality. And that means owning up to mistakes, being authentic, and for them to see sort of my left-hand scratch making its way up, I think is more effective. Hopefully, one has already earned the right to make errors because they're not, you don't want to be slick or I also think empathy is a huge part of all trial practice, but there's a difference between being empathic and being phony. And so I love the idea of the interaction part of it. I also like, again, my handwriting sucks. So writing the numbers, it's sort of shaky, and I'm nervous. And I don't mind them seeing that a little bit. Like just now, my left hand, even though I'm very left-handed, my right arm might as well be a leg. I'm so left-handed. But for some reason, my left hand is a little shakier than my right. So when I was going to take a sip of water here in this, I moved to my right hand because I didn't want to do one of these things. But I have done those things in trial where I'm, even though I'm in the moment and I'm not nervous, but my adrenaline is so high that my body is betraying that a little bit as being nervous. I don't think those are horrible things, but I also think I get self-conscious about it, which is why I shifted into my right hand. To wrap it up, I think the biggest changes are in demonstrative evidence, and how we use them, and how good they've gotten when, animations and those sorts of things. I saw one the other day that I thought was a movie. It was so good. And so those are really impressive things. And I think jurors love that. It is also fundamentally true, but this has been true for 20 years. The jurors' attention spans are getting narrower and narrower and narrower. So the need for demonstrative evidence has become greater, greater, greater. I just don't think one should confuse that for it having to be PowerPoint. I think that's the ultimate point here. Having things to hold are still vitally important.
How do you address that challenge with jurors and their attention span? First of all, where do you think that comes from, to the extent that you have any experience with it?
Yeah, well, I think it came culturally from Entertainment Tonight in the early 90s, and that evolved then into social media in 2009. There's sort of a direct correlation in 2008 and 2009 with social media and a dipping in human happiness. But I digress. I think that, when you're pouring through TikTok or Instagram and you go pass, and then you stay for a minute and then you go pass, our attention spans are just much, much shorter. So I think that the way to deal with that is twofold. One, I think our trials should be shorter and more efficient. And two, I think you need to give them what they need, which is, do you know anybody who isn't a visual learner these days? I know I'm a visual learner. I know there's a counterpart to being a visual learner. What is that? A verbal learner?
I know the old data, and it would be curious to see if that is shifted. The old data varies between 60 to 70% are visual learners.
Okay.
And then 20 to 25% are audible, meaning they best learn by hearing things. And then the smallest number is 5 to 10% for kinesthetic, people who learn through touching.
Okay.
And this is why we use visuals, because people tend to retain things better when it's visually. That gets to most of your jurors. But we also say it because they're audible learners. And then we have the models or the artificial knee replacement where they can actually touch it.
Yep.
The kinesthetic learners they tend to be the most forgotten in the classroom and also in the jury box.
Yeah, and I'm going to be a sort of contrarian, and I have heard those percentages, et cetera. I believe if you say it, you'll get some attention. If you show it, you're going to get much more attention. If you say it and show it, you're going to get maximum attention. And that even if still true that 20 to 25% are auditory learners, that's only 3 out of 12 of your jurors anyway. So you need to be visual, but it needs to matter, right? So I think one of the things that we've gotten better at is editing our cases and narrowing them to what really matters so that you're not deluging jurors with way too much stuff. I have a case coming up against Yamaha in a month, where we have so much that we are constantly editing it down so that our package that we present is coherent and doesn't waste anybody's time.
And I don't want to ask you granularity on a case that is going on right now in terms of strategy. Perhaps I could go back. I know you got a good verdict last year against the county of Sonoma. Am I correct about that?
Yes.
And perhaps we could look at that as a case where I know a lot of trial lawyers, a lot of people who are working up a case are worried that my jury they don't want to be there. They're, to a certain extent, they're like kindergarten kids. And this is something that I learned from Cynthia McGuinn, where you change the pacing and you need to make sure that everyone gets it. And sometimes that means hitting the same thing more than once.
Yes.
So how do you self-edit without having the fear that they don't have enough for you to prevail?
Well, first of all, the mere mention of Cynthia's name causes me to say, I was talking about some people who are naturals and who aren't. She's a natural to me. And that isn't in any way to denigrate her work ethic, which is supreme. And you know that better than anybody. But just her voice and her presence, she's ideally suited to be, and it's no surprise, she's the trial lawyer that she is. I feel like that case was so jury selection necessary. It's like your case that you tried in San Mateo, and you got such a great verdict and got so many jurors off for cause because of all of those things. And you and I got to talk about that.
And I'm going to stop you right there because I want to give credit where credit is due. And that is, we had a very good jury questionnaire that helped to deal with gay marriage and got a lot of people off just by answering the question that they didn't think that should exist, and they were off like that. But I think 10-minute, 20-minute conversation, you were kind enough to take a cell phone call as I was sweating picking a jury.
Yeah.
And the coaching me through using the phrase entirely impartial. And that resonated with our judge in a way that I'd never seen that, never done that before. And we had 150 panel jury, and I won't remember the exact number. I think it was 70 or 80 for cause in that case.
Holy Toledo.
Yeah.
And think about that, and think about how different an outcome it would have been. And so you mentioned that judge, this judge too, who was a tough judge for lots of reasons, but he also was a very good judge in lots of ways, absolutely appreciated those words. And this was a motorcycle case of a man who passed cars on the right who were stacked up at a stoplight to make a right-hand turn illegally in a shoulder. And a person who was in the front of the line took a right-hand turn at the same time that he made a right-hand turn, and he suffered horrible injuries as a result. But at first blush, it's like, that's a terrible case against Caltrans. Our argument was that the road was dangerous, and they had design immunity up the wazoo, and they didn't take the case all that seriously. And he was and still is married to a saint, given the nature of his brain damage and what it has left him as. The loss of consortium claim and the motorcycle claim and being against a public entity were such great fertile ground for cause challenges that in some ways, the worse facts that you have, the better you are at getting rid of those jurors who just are not going to be receptive to your case. And so when I think about what was the, pivotal moments in that case, it was the moments where the ones who we really didn't like, we challenged them on loss of consortium. Come on, this is for better or for worse. He agreed to that. She agreed to that. How do you feel about her being compensated for her husband's injury under, in the context of that vow? I agree. I don't think that's right. I mean, she made a deal and da-da-da. So loss of consortium, which is a tricky thing to decide to keep in your case. And you have to have, I believe, catastrophic injuries to do it. Otherwise, you're losing your best witness in a lot of ways. And yet we decided in this case to keep her in the case because he had catastrophic injuries, but also because it's I've really believed it to be a great way to pick a jury and to root out, to unpick your jury. And of course, motorcycles, once again, organ donors, that kind of language, getting that poison into the courtroom during jury selection is so important. And I think people are afraid of that poison, and I just welcome it because it's never as bad during the trial as it is during jury selection. So that really, really helped. And then we put on the defense witnesses first. We got some great testimony under our 776, and we just kept going. So it ended up a case that, on paper we shouldn't have won. If you were in the courtroom, we should have won. By the way, the best demonstrative evidence we had in that case was an expert investigator, actually, who sat out there and videotaped the intersection for an hour, and probably 90% of the local traffic, when there were cars stacked up, used the shoulder to make the right-hand turn because it was wide enough and looked like a turn lane and should have been a turn lane. And that's how we won the case.
Did you find that there were any challenges in terms of Sonoma County jurors and the fact that this was going to ultimately be a Sonoma County payout?
The good news there, the answer is yes, because it's not an easy county.
Right.
But it was a Caltrans case. And that made all the difference. I think if it had been against Sonoma County, that would have been a tough fact. One of the best pieces of evidence was our human factors expert also went out there, and the Sonoma County, like Golden Gate Transit bus, used the right turn lane, used the shoulder to make a right turn. And so there was the imprimatur almost of a public entity using it in the way that we said, you're calling that a technical vehicle code violation. We're telling you that's the safest way to make this turn. And that's the way people are doing it. And that's the problem. So while we used, you understand this is, against the state of California, this is taxpayer dollars. How do you feel about that? And got some cause challenges for that. It was sort of the best of both worlds because nobody thinks that the state of California is poor unless you look at the recent budget, which hadn't come out by then.
Tune in next week to hear part 2 of our conversation with Rich Schoenberger. And thank you for listening today. Please email us at podcast@coopers.law with questions, comments, feedback, and suggestions. Like what you heard? Share us with a colleague and leave us a 5-star review on Apple Podcasts. To all of you doing justice out there, happy hunting.